Thank you very much. And thank you for the invitation from the Law School of Columbia. Thank you to Michael, and thank you to Greg, too. You said that this afternoon it would be to know whether or not there should be a convention on displaced persons. Well, my own answer will be yes, it should be. And the specificity of this project is that it's not based on climate change issue, but on human rights approach, and for three reasons. First, because the reality shows that displaced persons exist not only for climate change reasons, but for many other environmental reasons. Secondly, because whatever the origin of the disaster, vulnerability of the people is always the same. And thirdly, I think that human rights law today seems more operational and effective than climate change law. As you know, there is a lot of displacement caused, well known, from natural disaster, environmental degradation, technological disasters, the new one, mixed disasters with Fukushima, the displaced person related with development work, and then displaced person as a consequence of environmental protection policy. And here there is a specific illustration related to climate change policy with the expel of a tribe in Africa, Uganda, the Bennett tribe, expelled from its land to allow offsetting tree plantation, implementing Kyoto Protocol. So the climate change policy induced displacement even in favor of limitation of climate change. This morning there was some data. Everybody knew that more people are displaced for environmental reasons than for war issue. And in the High Commissioner for Refugee Analysis in 2008, it was said that 1 centimeter of rising sea level gives 1 million of displaced persons. And then, as it was said too, most of the displaced persons, in fact, are in Africa. Nobody talked about Africa until now. 25% of displaced persons are in Africa for environmental reasons. And majority of displaced persons are internal displaced persons for 80% of the total. So the legal issue is to know if it exists in international law a specific legal regime for environmentally displaced persons. And the answer will be no. And it seems there is a lack in the protection of displaced persons at the level of international law. And the way to give a legal status to this person is to have a specific convention on the topic. It could be said that it's not necessary to have a new convention because already exists the Refugee Convention of 1951. But as it was mentioned, the legal definition of refugee can't apply to environmental displaced persons because of the notion of persecution and because of the interpretation, too, of the Refugee Convention, and because the Refugee Convention applies only to people crossing a border. And we saw that 80% of displaced persons for environmental reasons doesn't cross a border. they remain in their own state. There could be an amendment or a protocol to the Geneva Convention to open the definition of refugee for environmental or climate reasons. But anyway, the Geneva Convention deals only with individual situation, not with group, and mainly for political and diplomatic reasons, it doesn't seem possible today to reopen the negotiation of the Refugee Convention. It exists a document in international law, the UN Guiding Principle of Internally Displaced Persons of 1998, which include environmental displacements. But this UN guideline is not a convention. It's only a soft law instrument, and it doesn't cover the 20% of displaced persons crossing a border. So it seems necessary to have an international binding instrument to protect all environmentally displaced persons. And this instrument must be binding as a convention, not a guideline, because there are many guidelines in the topic, and must be ambitious. And to be ambitious is necessary to deal with human rights law at international level. The proposal for a new convention on international environmentally displaced persons is an academic proposal coming from the new city of Limoges with a group of research of environmental lawyers and human rights lawyers. And we had two versions of the draft convention. The second one of last year, you can find it on the website of the CIDCE.org. First, there is a question of terminology. Why environmentally displaced person and not environmental refugee? It's mainly because the word, the language refugee in international law applies to a specific category of people and with political implications, and it seems not necessary to confuse the vocabulary and to have a specific word for environmental refugee, environmental displaced person. And why environmental and not climate or not ecological displaced persons? To have a broad version of the topic and not to limit it to a specific category of disaster or a specific category of origin. And that's why we do not propose a protocol to the Climate Change Convention, not to limit the topic to a certain limited category of people. In the convention, in the draft convention, there is a definition: individuals, families, populations confronted with a sudden or gradual environmental disaster that inexorably impacts their living conditions, resulting in their forced displacement at the outset or throughout from their habitual residence. There are a lot of objectives and principles. The main objective is to guarantee the rights, individual rights and collective rights of environmentally displaced persons, and to organize their reception and eventual return in their state of origin. And for that, we think a universal convention could be a right answer. We could discuss for a regional convention, but as it is in reality the implementation of environmental law principles and human rights principles, principle of solidarity and principle of ecological assistance, which are in the Rio Declaration, application of the principle of common and differentiated responsibility, and to the principle much important in environmental law and in human rights law, the effective protection. We need effective protection, effective instrument, effective procedure of implementation. And to classical in human rights, the non-discrimination principle according to the Universal Human Rights Declaration. The general framework of the draft conventions is first to give to people this specific legal status of environmental displaced person, as it is a specific status of refugee. Second, to set up institutions at the national level to create instruments to grant this status. And third, to get an institutional framework general to have an enforcement of the whole system at the international level. First, to give rights to people, rights-based response, rights to persons threatened with displacement, that's the prevention of the displacement, which is much important in all disaster issues, giving right to information, to participation, and right to displacement or to refuse the displacement. And then a series of rights guaranteed to displaced persons, which are the traditional human rights specifically applied to the specific situation: assistance, housing, care, juridical personality, respect for the family, the right to return, the right to move freely. And here I mention a recent precautionary measures from the Inter-American Commission on Human Rights about Haiti, saying, the Inter-Commission said, asked the state of Haiti to adopt a moratorium on the expulsion from the camps of internally displaced persons. That means that there is a jurisprudence now for internally displaced persons in relation with the free movement of the people inside temporary installations. The right to return home, the right to prolonged shelter, and right for interstate displaced person, principle of non-refoulement, right to return, right to conserve the nationality of origin, and then collective rights of families and population, preserve their unity, and right to cultural specificity. But after the recognition of these different rights, there should be a procedural system for the recognition of the status given to each people. There should be an application to a national commission of independent members in each state with a specific mechanism of appeal to an international body, because the question of the Geneva Convention on Refugee is that there is no international appeal, no international control. It's all in the hand of each state. Here we want to make a progress in human rights protection and to have a relation between the National Commission giving the status and the capacity for the people to appeal to a high authority at international level. The displaced person, the National Commission, and the authority at the level of the convention. That means that it can work only if there is institutional framework. So people say it will be very complicated to have a lot of new institutions inside the convention. But the reality shows that the only system on human rights which works are the system where there is institutional bodies and implementation control. And so on, there should be a world agency for environmental displaced persons with the role of prospective, assessment, assistance, world funds too, and the specific role of this high authority with a legal job on granting or refusing the status at the level of appeal, interpretation of the convention, and to assessing the compliance of the convention using the well-known mechanism existing now in environmental law of compliance committee. In conclusion, we could say that it's necessary to have a global, not sectoral approach, a global and holistic approach. Disaster victims must not be human rights victims. There is a urgent humanitarian necessity because we have shown the data and figure existing now of the millions of people in that situation. And it needs institutions because there is not effectiveness without institutions. And I think it's a good illustration of a necessary synergy. It was shown this morning too, the synergy between environmental and human rights law. I must mention that it's not a utopic vision. The International Law Commission is working since 2 or 3 years on writing articles on the protection of persons in the event of disasters. And in that work of the International Law Commission, they already find a definition of the disaster, a legal definition of the disaster, and they have a broad vision, not a sectoral vision of categories of disaster, a broad vision including all preventive measures and all reparation measures and all elements we mentioned already. There is too the UNEP Environmental Law Program. In the last Montevideo program of 2009, in a point of the program, UNEP says we should prepare a feasibility study on a convention on environmental displaced persons. Well, UNEP thinks to a feasibility study 2 years ago. We think we must have not feasibility study, but a real convention existing and drafting as it is there. And all the human rights context existing now, for instance, I mentioned these precautionary measures from the Inter-American Commission on Human Rights to on displaced persons, the recent decision of the Inter-American Commission about Brazil with the Belo Monte hydroelectric project and about Argentina in April of this year, where the Inter-American Human Rights Commission says to the state, you should stop some works when there is consequences on people with displaced people in Argentina, in Brazil, and in other places. So our objective now is to use this draft convention and to find a state being able to take it in account and to put it on the table, because that's the way a project can go in international negotiations. And we have a good opportunity with the next year big Rio conference, Rio plus 20. And we are trying to put on the table of the Rio conference a project, not specifically this project, but the topic of the legal necessity to have a legal instrument, a binding instrument in the future on environmental displaced person. And we are testing in a research project of the University of Limoges, we are testing the implementation of this draft convention in 7 states, in Brazil, Argentina, Cameroon, Vietnam, Turkey, Tunisia, and France, to test the implementation of this draft in national migration law, to see how it could be applied and how it will modify or not much modify national legislation on migration. And this testing of this draft convention can be very interesting to make an adaptation of the content of the draft for the future negotiation. Thank you very much.
Thank you very much. Let me just mention in response to a couple of questions that I've received about the PowerPoints, we do plan to post the PowerPoint presentations where the people presenting them have given us permission to do so, which is most of them. It'll take us a few days, so you can look for them next week, but we do plan to post them. And our next speaker is David Hodgkinson of the University of Western Australia.
Thanks, Michael. It's a pleasure to be on this panel this afternoon with Michelle and with Jane. Michelle's proposal has been very instructive and very helpful to us, and I've corresponded with his colleague Julian Bataille. And Jane's comments regarding a climate change displacement treaty have also been very useful in further refining our project. What I propose to do this afternoon in the 15 or 20 minutes available to me is to examine why a convention might be useful, why a convention, outline the main features of our convention, and conclude with some provisions which might be applicable to small or threatened island states, and to differentiate these states from others which might be affected by large-scale displacement. The title of this presentation comes from a chapter in a recent publication called At the Water's Edge, in which the authors state that throughout the Pacific generally, sea level rise has generated plans for the relocation of populations in the face of looming catastrophe. So why a convention? Current protections at international law do not adequately provide for the number of categories of person likely to be displaced by climate change. For example, it seems clear, as we've heard, that persons displaced by climate change would not be the subject of protection under the 1951 Refugee Convention. It's also the case that most displacement due to climate change may be internal. Most climate change displaced persons, and we use the acronym CCDP, we understand will not cross national borders. There are many other proposals for a new instrument providing for people displaced by climate change. Some proposals seek, in various ways and for various reasons, to link that instrument with the United Nations Framework Convention on Climate Change and its Kyoto Protocol, Beerman and Boas, for example. But neither the UNFCCC process nor Kyoto contemplate or address the issue of displacement. The UNFCCC, notwithstanding its focus on adaptation as well as mitigation, has limitations as a framework for dealing with climate change displacement. Its structure and institutions are not designed to address it. And further, as the 2009 Copenhagen Conference and the 2010 Cancun Conference reveal, the UNFCCC cannot be easily amended or protocols added in order to accommodate CCDPs. Dealing with existing provisions for that regime is already problematic. There is no coherent multilateral governance framework for CCDPs. Regulation is extremely fragmented and disparate. Neither existing climate change law nor refugee law adequately provides for displacement. There's been no coordinated response by governments to address human displacement, whether domestic or international, temporary or permanent, due to climate change. And given the nature and magnitude of the problem which climate change displacement presents, ad hoc measures based on existing domestic regimes may lead to inconsistency, confusion or conflict. It seems the international community may have an obvious interest on security and economic grounds at least in addressing the problem of human displacement in a coordinated fashion, in providing preemptive resettlement to those most at risk in terms of the impacts of climate change. We propose a single multilateral, standalone convention to address the problem of climate change displacement, the scope of which, like the problem, in terms of both causation and consequences, is global. Parties to the convention would include both developed and developing states. And while our proposed convention is a standalone instrument, it does draw upon and adapt provisions of other instruments to adequately provide for, to assist and protect those displaced by climate change. And adopting a multifaceted, cooperative and international approach to providing for, assisting and protecting CCDPs, our convention encompasses those displaced internally and those that cross an international border. Migration experts state that most persons displaced by climate change will be, again, unlikely to cross an international border. Most are expected to remain within their home countries, although as distinct from small island states. Developing state parties to the convention, with economies dependent on the natural environment, but without resources to mitigate and adapt to the effects of climate change, will be those states most in need of displacement assistance. So our convention proposal, in addition to some of the matters just raised, persons displaced within state borders would be subject to a framework of assistance in which obligations would be shared between the home state and the international community. In the case of CCDPs that have migrated across state borders, the convention would outline the rights and obligations of the CCDP and the home and host state. Current levels of scientific knowledge create causality issues regarding the extent to which climate change contributes to a particular weather event or population movement, and the convention would adopt a very likely standard to identify certain phenomena and trends as consistent with climate change and human contribution. And instead of assigning rights and protections on the basis of the individual satisfaction of definitional criteria, as in the Refugee Convention, we believe that en masse designation of CCDP status is more appropriate to the characteristics of climate change migration. And the very real prospect of entire states becoming uninhabitable differentiates the plight of threatened island nations from other regions in which there is likely to be large-scale displacement and requires specific consideration. The Convention contemplates the collaborative provision of preemptive assistance and, if necessary, resettlement to those most at risk in terms of the impacts of climate change. Provision of assistance under the Convention then could perhaps be described as anticipatory adaptation. As we know, science can determine neither whether a particular environmental event was caused by climate change, nor the extent to which humans contributed to specific climate change events. The Convention would recognise problems with determining the extent to which climate change causes an event giving rise to displacement, identifying certain phenomena and trends as consistent with climate change, and establishing the extent to which humans contribute to particular or general climate change events. And again, our convention proposal would adopt a very likely standard, that is greater than 90% probability, according to the IPCC, to identify certain phenomena and trends as consistent with climate change and human contribution. And this higher standard provides increased certainty and targeted resource allocation in the context of a convention that could apply to hundreds of millions of people. And by adopting the very likely standard, and in the light of the current state of climate change science, we anticipate that requests from state parties attracting the operation of our convention would overwhelmingly concern slow onset, gradual displacement, which is more likely to be established as induced by anthropogenic climate change than a sudden disaster. And while the scope of our convention does include those persons displaced as a result of a sudden climate change event or impacts, as a practical matter, the proposed convention's machinery or architecture may not be suited to immediately reacting to an unforeseen disaster. and attempts to actually apply the Convention in those situations may prevent the operation of existing and more effective assistance and disaster relief and management programs. Multiple channels through which aid, assistance and protection are provided to those displaced by sudden environmental impacts already exist. Our proposal sets out a climate change displacement organisation, or CCDO. That's the last acronym I'll use. And within that structure, set out the roles and obligations of Convention participants. The Convention framework contemplates that states providing displacement assistance and funding and states receiving such assistance and funding would be parties to the Convention. And the Convention limits the provision of assistance to developing state parties, and a developing state party would make a request to the CCDO for internal or international resettlement assistance, and that state party would, at the time of making a request for assistance, also request en masse designation of the status of CCDPs. And such an approach would require a definition of CCDPs because, as Castles observes, we cannot get around definitional categories easily, for definitions are crucial in guiding the policies of governments and international organisations towards mobile people. We propose then the following CCDP definition. CCDPs are groups of people whose habitual homes have or will become temporarily or permanently uninhabitable as a consequence of a climate change event. And a climate change event is defined as a sudden or gradual environmental disruption that is consistent with climate change and to which humans very likely contributed. And developing state parties may also make financial and other requests for assistance in fulfilling their Convention obligations. These obligations would include collecting data on climate change displacement, integrating protection and assistance to CCDPs into future planning programs, and consulting with potential or actual CCDPs and their representative organisations in the collection of data, the development of policy and its implementation. Again, the Convention would largely operate prospectively. Assistance to CCDPs would be based on a bottom-up, top-down approach, assessment of the likelihood of their environment becoming uninhabitable due to events consistent with anthropogenic climate change, such that resettlement measures and assistance were necessary. In other words, we view displacement as a form of adaptation that creates particular vulnerabilities requiring protection as well as assistance through international cooperation. As Mastrandrea and Schneider note, success in adaptation to climate change will come from the mating of top-down and bottom-up assessment. Scientific projections are most useful when joined with the intimate knowledge of existing vulnerabilities that stakeholders possess. Detailed bottom-up studies provide understanding of the structural, institutional, financial, legal and cultural frameworks of affected sectors and communities. And there are clear virtues in formalising regional arrangements. Accordingly, we propose the establishment of regional committees which would inform CCDO decision-making of regional perspectives and enable the unique situation of small island states to be addressed, in part through the conclusion of bilateral displacement agreements, and more on those agreements in a moment. We propose, in terms of financing, that developed state parties to the Convention make mandatory financial contributions to a climate change displacement fund, and that such contributions are made on the basis that, at least as a starting point, state and state parties to the Convention have common but differentiated responsibilities. We recognise problems with this principle, perhaps most obviously in the Kyoto Protocol, and in determining the hard issue of the level of specific state party contributions to the fund, it may be that actual state party and other contributions would be largely a matter for negotiation. And of course, adaptation funding generally is difficult, as we've heard in respect to the UNFCCC process. And while our Convention applies to both internal and trans-border displacement, it would take account of the clear distinction drawn in international refugee law between refugees and the internally displaced. Again, most climate change displacement is likely to occur within state borders. The guiding principles on internal displacement provide a coherent statement of the matrix of human rights and humanitarian protections that are applicable to IDPs. The guiding principles recognise that national authorities have the primary duty and responsibility to provide protection and assistance to IDPs. However, it's our view that because climate change is a global problem, the international community has an obligation to provide assistance to CCDPs regardless of whether their movement has a trans-border dimension. The Convention would provide a framework for the provision of assistance and protection of persons internally displaced due to climate change, in which obligations are shared between the home state and the international community. And in the case of those displaced across borders, our Convention would outline rights of the CCDP and obligations of the host state. Again, the operation of our Convention would in many ways be prospective. State parties again would be required or obliged to collect reliable and relevant data on climate change displacement and closely consult and actively involve potential CCDPs and their representatives. Given time constraints, I'll leave assistance and protection in terms of international displacement generally and turn finally to small or threatened island states specifically. The possibility of effective loss of homelands differentiates threatened island nations from other regions in which there's likely to be large-scale displacement and requires specific consideration. More broadly, it may signify the end of unique ways of life which are intimately connected to precarious physical landscapes. Existing legal regimes do not adequately articulate the rights that should be accorded to CCDPs from threatened island nations in order to recognise this loss. And we provide for discussion at this point, like the Convention itself, that the principles of proximity and self-determination, at least, should be applicable to regional bilateral displacement agreements between threatened island nations and host states, such agreements to be negotiated under the aegis of the CCDO. It's been suggested that a climate change treaty should be implemented with recourse to a principle of proximity, which requires the least separation of the person from their cultural area. Proximate resettlement of threatened island nations may be particularly appropriate given strong connections to both land and seascapes. And a principle of proximate resettlement should guide those bilateral agreements of which I just spoke. And in the context of threatened island nations, articulation of self-determination is particularly useful. We consider self-determination to be relevant to two distinct elements of relocation. When will people abandon their territories, and where will people choose to resettle? So first, the Convention would recognise the citizens of threatened island nations may want to remain in their home state for as long as is practicable. The capacity of the proposed Convention's fund to provide prospective resources for persons likely to be displaced by climate change would enable adaptation funding to be provided. And in this regard, we note the work of Barnett and Campbell in Climate Change in Small Island States, in which they say that focusing on large-scale adjustments in social systems or large-scale engineering works is likely to be a less effective and efficient approach to adaptation than multiple small-scale processes to build adaptive capacity at the community, local government and national government levels. These approaches do not mean that the international community is absolved of responsibility for adaptation. Adaptation responses are likely to have major costs, little if any of which should be borne by communities forced to take adaptive action. And this principle of self-determination should also apply to the second aspect of relocation, the destination to which small island states, CDPs, relocate. And while proximity is also relevant here, collective self-determination could inform agreements between threatened island nations and host states. Preferences may relate to existing migration patterns, or proximity, and should, to the extent possible, be adhered to. Our aim, though, above all, is to enable people to remain in their homes for as long as possible, or to move in a planned manner over time. Finally, our convention recognises the effects of climate change on populations. This is reflected in our inclusion of en masse CCDP designations, and finding, as Harvard's Doherty and Giannini do, that group status determinations increase opportunities to formulate solutions that would keep the integrity of a group intact, which could help preserve cultures and national identities. Our project emphasises the importance of the maintenance of the CCDP group's social and cultural cohesion in their host country. I do have a note here with regard to a climate change regime complex, or a building blocks approach of which a climate change displacement treaty could form a part, but I know that timing is an issue, so I might, if I may, simply move to a conclusion. And by way of conclusion, if I may, I'd end with this comment from a recent study on climate change displacement in the Pacific. And that is that planning for a future of mass displacement due to climate change gives us the opportunity, before millions of people are on the move throughout the world because of climate change, and before we and other nations become tempted to erect walls to keep them at bay, to develop frameworks and institutions that might not only be politically realistic, but also based on principles that promote human rights and dignity. Thanks. Thanks for your time. Our project has a website, ccdpconvention.com. Please visit the site, and of course, if you have any questions or require further information, just let me know. Thanks again.
Thank you very much, and it is now my pleasure to call upon Jane McAdam of the University of New South Wales.
Thank you very much, Mike, and thank you to Columbia Law School for hosting this very important conference. At the outset, I would just like to point out that although I don't have a PowerPoint presentation, I do have some hard copies of the article on which this presentation is based, if anyone would like a copy of that afterwards. One of the biggest shortcomings of much of the scholarship that's being generated in the field of climate displacement or climate migration is a tendency to treat much of climate-related movement as though it were a single phenomenon that can be discussed in a general way. However, a number of very different kinds of scenarios are captured within this rubric, and it is only through examining them separately, with attention to their distinctive as well as their common features, that any meaningful policy or normative frameworks can be developed. Certainly, a one-size-fits-all approach will not adequately respond to the variety of movement encapsulated within the climate migration framework. For example, people may move as a result of slow-onset climate processes taking place over many years, and the threatened island nations fit within that kind of notion. Or perhaps because a government chooses to relocate people out of harm's way. Alternatively, there might be a sudden disaster that precipitates movement. What is clear is that in each of those different scenarios I've mentioned, different kinds of pressures or impacts will affect the nature, the timing, the speed, and the size of movement, and therefore the kinds of solutions that are required. A sudden disaster like a cyclone may precipitate very fast flight, but it may only be temporary, and assistance in the form of humanitarian disaster relief may be a sufficient response. By contrast, climate change impacts that take place over a much longer period of time, through things like erosion or drought or salinity and so on, may ultimately necessitate the relocation of people to, in some cases, other countries. Now, in such cases, the planned long-term relocation of communities may need to be negotiated with particular states or perhaps through an international burden-sharing agreement. What is essential, though, is that our thinking about legal and policy responses is informed by real geo-social political contexts. Otherwise, there's a risk that the solutions we envisage will be inappropriately targeted. They must reflect understandings based on empirical evidence about the nature, timeframes, scale and duration of projected movement. The lack of a clear international legal framework to respond to people displaced by climate change has resulted in a number of different actors calling for different kinds of climate change climate change displacement instruments so as to protect people who are forced to flee. And we've heard a couple of those kinds of proposals today, but they vary from things like a new protocol to the Refugee Convention, to a protocol to the UNFCCC, or a standalone treaty. Some of which include a defined legal status for the people who move, as well as resettlement and or integration solutions. Now, while the underlying basis of each proposal is presumably to provide a rights-based framework for people forced to move when the impacts of climate change render life and livelihoods at home impossible, in my view, it's not self-evident that a treaty would presently best serve this end. Drawing on fieldwork that I've undertaken in the Pacific Islands of Kiribati and Tuvalu, as well as in Bangladesh and India, I argue that advocacy for a new treaty to address climate-related movement is misplaced for a number of reasons. There are both conceptual and pragmatic difficulties in attempting to construct a refugee-like instrument for people fleeing the effects of climate change. There are four main reasons why. First, treaty proposals are premised on certain assumptions about climate change and human movement that are not borne out in the empirical studies that are emerging, which show that movement is likely to be predominantly internal and or gradual, rather than in the nature of refugee flight. Secondly, it's conceptually problematic and empirically flawed to suggest that climate change alone causes movement. Thirdly, there seems to be very little political appetite for a new international treaty on protection. And finally, focusing on a treaty may obscure other approaches that may actually better align with the needs and the desires of affected communities. So what I want to do now is to examine each of those in turn. Firstly, looking at empirical evidence on movement. A particular challenge for any new treaty is adequately accounting for slow onset movement brought about by gradual environmental deterioration as opposed to flight from sudden disasters. The refugee and complementary protection paradigm, which premises protection needs on imminent danger, doesn't capture the need for safety from longer-term processes of climate change, which may ultimately render people's homes uninhabitable. As fieldwork conducted in Bangladesh, for example, showed, even if initial movement from a disaster is rapid, it will almost certainly be internal movement. There is in fact very little evidence of cross-border movement from Bangladesh into neighbouring countries such as India. And what was fascinating was that in India we could find hardly anybody who was even studying this phenomenon, which I think says something about some of the projections in terms of mass international migration. Even longer-term migration is predominantly within Bangladesh itself, largely because people's poor socioeconomic circumstances preclude them from undertaking cross-border journeys. People simply don't have the resources to do this. Some people will move intra-rurally while a large number of people, as we've heard, will move from rural into urban areas within Bangladesh. Temporary and circular migration is a common longer-term survival strategy. Since the people who are displaced remain citizens of Bangladesh and therefore are entitled to the protections that flow from that status, they will likely be treated as a domestic concern and not within the purview of international attention. Similarly, turning to the Pacific Island states of Kiribati and Tuvalu, people living on the outer islands will initially move internally to the main island, not directly overseas. International movement from Pacific Islands is likely to be more preemptive in nature, planned movement in response to slow onset changes that gradually degrade the islands, rather than in the nature of sudden flight. And in fact, social processes that create poverty and marginality are more important determinants of migration outcomes than environmental changes per se. Each of the various movement scenarios that I outlined at the beginning of the presentation involve different kinds of pressures and impacts which will affect the ways in which people move. What this means is that at various points in time, the role of climate change in individual or household decisions to move may be stronger or weaker. The reality of movement is complicated, and a vast range of factors influences people's decisions to stay or to go. Now, certainly climate change is having real impacts on the lives of people in the countries that I've mentioned. But in most cases, in fact in virtually all cases, it is only one of a number of reasons why people decide to move. And this is because climate change tends to multiply pre-existing stresses rather than causing movement on its own. As one government official in Kiribati observed, climate change overlays pre-existing pressures such as overcrowding, unemployment, environmental fragility and development concerns. So it means that it acts as a tipping point that might not otherwise have been reached. For this reason, some researchers argue that it's arbitrary to single out climate change as a driver of forced migration, while omitting other causes such as poverty, general conflict, or lack of opportunity, especially since these things may in fact impact on even more people than climate change may. These scholars instead prefer the term survival migration to encapsulate the reasons why people may move. And they argue that this shifts attention away from a particular cause, in this case climate change, and instead towards a more comprehensive understanding of the multiple pressures that affect people's movement decisions. Now, of course, there's a danger that something like survival migration can be an all-encompassing term, just another term for forced migration, really. And so in practice, it's probably conceptually indistinct and unworkable. But I think it is useful to bear this in mind when thinking about international policy responses and also about international governance in terms of institutional responsibility, because it does affect the ways in which we conceptualise what climate change-related movement is and how we go about responding to it. In particular, I think it is worthwhile to query the appropriateness of singling out a category of climate-induced displaced people, or whatever we might wish to call it, in an international treaty, particularly since much of the responsibility for movement resulting from these other drivers I've mentioned, like general poverty, may be similarly attributable to international structures that perpetuate an ever-growing divide between rich and poor countries. So in other words, should displacement be addressed in terms of what drives it, or in terms of the needs of those who move? This issue of multi-causality is not in and of itself a sticking point for any international treaty. For example, in international refugee law, the Refugee Convention doesn't require persecution to be the essential and only reason why somebody might flee their home. And so it does, you know, in theory, the Refugee Convention acknowledges that there may be other reasons why people might leave, but as long as a person can show they have a well-founded fear of persecution, that's really all that would be focused on in that refugee status determination decision. But any treaty that would premise movement on climate change must, by definition, require a person to be able to establish some causal link. And I think this raises a number of causation hurdles that would be quite difficult to jump. First, a decision maker would need to assess the nature of the alleged harm feared. So let's say, for example, that a person is arguing that they simply don't have access to food because of saltwater intrusion on agricultural land. So the decision maker has to assess that harm and whether the source of that harm is attributable to climate change. Now, some of the treaty proposals have actually suggested the establishment of an expert scientific body to determine this in each case. In my view, this is unworkable in the protection context. It misplaces the real focus of the inquiry, which should be on the nature of harm feared if a person has to return home. Indeed, such an inquiry would seem to require a considerable degree of latitude because, as we know from climate scientists, it may take decades before climate change can be scientifically verified as an underlying cause of any particular event or process. Thirdly, the decision maker would need to assess whether the harm that's feared amounts to a sufficiently severe violation so as to attract the protection of the treaty. Given that climate change is bound up with underlying socio-economic circumstances, the degree to which climate change can and needs to be singled out as a factor would need very careful consideration. These levels of complexity could lead to quite considerable difficulties as well as inconsistencies in decision making. And again, they raise that underlying question, why should climate change be the key? These conceptual critiques are linked to a more pragmatic one, the fact that states presently seem to lack the political will to negotiate a new instrument requiring them to undertake even more international protection obligations in respect of additional groups of people. Any treaty is necessarily an instrument of compromise, and even once achieved, states must demonstrate sufficient political will to ratify, implement and enforce it. In light of the legal obligations that states already have towards convention refugees, and the fact that some 10 million refugees today, not to mention other displaced people numbering close to 43.5 million, have no durable solution in sight, why would states be willing to commit to, and furthermore to realise protection for, people displaced by climate change? In responding to the first of these questions, it could be argued that states might be prepared to adopt such an instrument, precisely so that they can call for shared responsibility. For example, an individual state might perceive a need to respond to potential arrivals of climate-displaced people, but be unwilling to unilaterally create legal avenues for their protection. Were it to elicit the support of other states in adopting a treaty, however, then its humanitarian impulse could be coupled with mutual self-interest, in that it could then call on other states to share the responsibility of caring for such people. But it's in response to the second question, why would states be willing to realise such protection, that real difficulties arise. As we see with the present refugee regime, problems of implementation and durable solutions, or rather a lack thereof, stem predominantly from a lack of political will rather than an absence of legal frameworks. Despite the 147 states parties to the Refugee Convention and/or Protocol, the plethora of soft law relating to refugees, and an international institution, UNHCR, with the strong institutional presence as well as a very strong operational presence, the displacement of millions of people remains unresolved. From an advocacy perspective, one can appreciate that lobbying for a climate displacement treaty may generate attention and may place climate change-related movement on the international agenda. But it's imperative that advocacy is well informed. If empirical evidence doesn't support the claims being made, then it won't achieve its ends and could ultimately backfire. Messy or alarmist work can lead to attempts to discredit the phenomenon of climate-related displacement altogether. And we've actually had some recent examples where this has been the case. First of all, in 2010, New Scientist reported that there had been scientific reports that Kiribati and Tuvalu were in fact growing, not disappearing. And then again earlier this year, a 2005 UNEP report endorsing the claim that there'd be 50 million climate refugees by 2010 was lambasted in the media for its inaccuracy. Both of these examples highlight the dangers of portraying climate change as a sole driver of displacement. The first example, the growing rather than disappearing islands, overlooks the fact that underlying socioeconomic conditions mean that some migration from Pacific islands, such as Tuvalu and Kiribati, is inevitable, as it has been historically. So whether or not the islands are growing or disappearing will have little impact on the need for migration options. Similarly, the second example highlights the danger of adopting figures that have been derived from problematic methodologies, especially when we have no reliable mechanism to count those who move for climate-related reasons. So figures that there will be 50 million up to 250 million people displaced by climate change by the middle of this century are very, very difficult to accurately predict. They came out of a methodology adopted by Norman Myers, a sociologist, who a number of years ago looked at a map of the world, identified the disaster hotspots of the world, and then looked at what the projected population would be by 2050 and said that's the number of people who'll be displaced. What those figures don't do is take into account people's resilience. They don't take into account adaptation nor mitigation, and they don't differentiate between internal displacement or cross-border displacement. So they're very, very problematic when adopted as statistics on climate-related movement. These are all cautionary tales for the present context if we start talking about a climate displacement treaty, if not supported by empirical evidence. As well, the displacement discourse effectively circumvents careful consideration of adaptation measures that could be supported by the international community to prevent forced migration. And it also, this displacement discourse also can neglect the role of individuals in determining their own responses based on their own needs and values. For me, all this relates back to the key question of how best to protect and promote the human rights of affected communities. While international human rights law principles should inform any decisions and responses relating to human movement, a protection-like response may not necessarily respond to communities' human rights concerns, especially those relating to cultural integrity, self-determination and statehood. It may also obscure other human rights that deserve attention. My concern is that if a treaty becomes the main focus of international policy development, attention may shift from the more immediate, alternative and additional responses that may enable people to remain in their homes for as long as possible, which is the predominant wish among affected communities, or to move safely within their own countries where possible, or to migrate in a planned manner over time. While international cooperation on climate-related movement is sorely needed, And I think that the Cancun adaptation framework, which acknowledges migration and relocation as a form of adaptation, and therefore something that can attract adaptation funding, perhaps provides a first step towards international cooperation in this respect. I want to caution against squeezing all forms of forced movement into a protection paradigm, because this might not best address the needs of those affected. So in conclusion, legal and policy responses must involve a combination of strategies rather than an either-or approach. Localised or regional responses may be better able to respond to the particular needs of the affected population in determining who should move, when, in what fashion, and with what outcome. Staggered migration, circular migration, or the promise of a place to migrate to should it become necessary might be welcome measures that could appeal both to host and affected communities alike. Furthermore, by contrast to many other triggers of displacement, the slow onset of some climate change impacts provides a rare opportunity to plan for responses rather than relying on a remedial instrument in the case of spontaneous and often desperate flight. Thank you very much.
Thank you. We've had a very interesting diversity of views. Let me now invite comments from the audience. Yes.
Good afternoon. Thank you to the panelists for two very interesting perspectives. My name is Ian Rampasad. I'm from Trinidad and Tobago. I work at the International Law and Human Rights Unit in the Office of the Attorney General. My question is, how would you convince a government that signing a proposed convention would not come with an onerous economic burden or even specific socio-political burdens?
What if you'd like to?
It's difficult. I think Jane and I, notwithstanding apparent differences, actually agree on quite a lot in terms of our respective proposals. But I think the one thing that we would perhaps both agree on is that the hardest thing is signature, ratification and enforcement of any climate change displacement treaty. I think there are good arguments, and I hope that I've presented some of them, particularly given that our convention is concerned ultimately with adaptation and slow onset events as opposed to a focus on rights. But nonetheless, notwithstanding that, and I think that the useful reasons as to why a state may well sign up, I think treaties generally are difficult. My background is in aviation treaties, and there's a lot of self-interest involved in those treaties, but even then and there it's difficult. So there are a range of obstacles to a treaty, and I think perhaps the most significant one is the signature ratification issue. There's no question about that. It's a difficult thing.
Thank you. It's Mustafa from Bangladesh. I understand that there is a multi-causality problem of multi-causality in environmental or climate change migration, because the decision to migrate is dependent on various other socio-economic factors. But in response to Jane's presentation, actually, I like to share my experience with the climate change displacement. I am from the coastal city, most affected part of the Bangladesh southwest part. My home district is there. So they are already in Cox's Bazar, the southwest part, which is the longest sea beach is there. And you will find slums in the name of the island, two islands, Kutubdia and Moheshkhali. The people from Kutubdia and Moheshkhali, they are coming to city, Cox's Bazar city, and they become the human puller, the rickshaw puller, because they are displaced to climate change. I understand it is difficult to measure, but there are certain cases. For example, I know many people who displaced only due to the impacts of climate change, and it is confirmed by the IPCC that the salinity intrusion is due to impacts of climate change and sea level rise. In Kutubdia and Moheshkhali, the salinity actually diminishes the fertility in agricultural land, and the farmer, they lost their land and they lost their livelihood, and that's why they moved to city for other in search of other livelihood. And obviously, it's not easy for them to migrate abroad because it needs resource, money, and education, everything. But if they're given opportunity to, obviously, the very first opportunity, from my experience, I can confirm that very first opportunity they will opt for settling abroad. They will interested to settle abroad because they lost livelihood and everything. I like to, in this context, I like to refer one, the other argument, that is, from Myanmar, there are many Rohingya refugees in Bangladesh. And the ICRC settled 20 to 30 people to Canada as part of relocation program and as part of international burden sharing. And thousands of people from Myanmar, Rohingya refugees, they came to Bangladesh with the hope that they will go to Canada. If they come to Bangladesh, but through the ICRC, they can settle to Canada. So I think it's, obviously it's difficult, but it's impossible to measure the tipping point and to identify the real climate change refugee. Obviously, in certain cases, it's possible. And in response to the presentation by David Hodgkinson, actually, you proposed for the treaty for climate change displacement who are displaced due to the very likely impacts of climate change. And so I understand that narrowing the definition is good for providing the effective protection, but if you keep the definition very narrow, then large number of people who are displaced due to the impacts of other impacts of climate change. So what protection you suggest for those people? Maybe some other people also will go for protection for these people, and so I think it's also fragmentary or not, as I want to respond to it. Thank you very much.
Thank you. Would either of you like to, any of you like to say anything?
Thank you, Mustafa, for that comment. Just one observation that I'd have is it was in fact from visiting slums in Dhaka in Bangladesh that I suppose, if you like, the arbitrariness of climate change came to the fore, in that talking to people in slum areas, if you ask people, why have you come here? Some would identify an environmental reason, some would identify an economic reason, others would, there were a variety of reasons that people used to self-identify why they had moved. And I thought, if you were to come in here and actually try and pinpoint where is climate change the cause, and yet look at the appalling conditions in which everybody in that slum was living, why should climate change be the factor that then triggers some sort of protection response? One of the human rights NGOs in Bangladesh, when we posed that question to them, they said, well, I suppose you would argue that climate change is something that has been caused by others, not by these people, not by us, and therefore the international community has a special obligation to respond. But as I was saying, I think you can make a similar argument in terms of economic structures that, could account for the impoverishment of those people as well. So I'm not trying to suggest climate change doesn't have an impact, but I do think it's incredibly difficult to disentangle it. And in terms of, some of the poor development practices that were cited and corruption with shrimp cultivation and people building, kind of putting watercourses through land or through riverbanks that then collapse more easily, all of that is part of the environmental degradation that we see occurring. And look, I realise that the more problems you accumulate, perhaps the more difficult it is to convince states they need to respond, because in their mind that's even potentially more people that you're talking about who need assistance. But I do have a kind of, I suppose it's an ethical concern with why single out climate change in terms of driving responses, and not looking at the underlying causes as well.
I'm Romel Casis from the University of the Philippines. If we accept the premise that we need some form of legal framework because the Refugee Convention and the UNFCCC, both instruments are insufficient to protect climate change displaced persons, it seems that our options would be to have a protocol to the UNFCCC, an amendment to the Refugee convention or an entirely new convention as discussed. But why should we choose a new convention vis-a-vis the other options? It seems to me that drafting, ratifying a new convention would be as difficult, if not more difficult, than the other options. I noted that in David's presentation, a number of the provisions of the new convention they propose actually are the contentious provisions of the current climate change negotiations, which would be providing funding from the north to the south and providing technical assistance. So it seems that it would be even more difficult, and it would distract from the current negotiating process. So maybe we could hear from the panel what would be the advantage of choosing a new convention, considering the greater difficulty in trying to arrive at one.
Thank you. Thanks for your question. I think the difficulties with reopening or amending the Refugee Convention, the 1951 Convention, and also drafting a second protocol to the UNFCCC are fraught with difficulty. I suspect that both are unlikely, particularly given the experience with regard to the Kyoto Protocol and the myriad of issues which attend that. As a result of those difficulties, in part, that's why we propose a convention for climate change displaced persons, and we hope to deal with some of the issues that you have identified by issues such as a focus on internal adaptation, a focus on slow onset gradual events, and also a very likely, in terms of causation, a very likely standard, that is 90%, so as to ensure that the operation of the convention has that particular effect. I should say, as I said in my earlier response to an earlier question, that these are hard issues. Treaty generally is difficult, let alone one on a subject like climate change. But given the virtues of a climate change treaty that focuses on adaptation to climate change, focuses on slow onset events and adopts a very likely standard, a 90% standard, it's one that could perhaps work. Be difficult, but in any event, I think, given that one's starting from scratch in terms of drafting a treaty, easier than either amending the UNFCCC through a protocol or additional protocol, or indeed amending the Refugee Convention. Jane's far more knowledgeable with respect to the Refugee Convention than I am, but I suspect amending it in this regard would be fraught. Thank you.
Michelle, would you like to add anything?
No, just I think the problem is to know what will be the advantage of a specific convention on climate change displaced persons in relations with a broad one. Because if you have a specific convention on climate change displaced person, what will be in the future the legal status of displaced person for other disasters than climate change?
And it's very much it's clearly a treaty that's pardon me. It's clearly a treaty that's focused on climate change. And so in terms of displacement, non-climate change displaced persons, as it were, their situation would not attract the operation of this particular treaty, focused as it is on climate change displaced persons. And, you know, in terms of Jane's question, I think why is climate change the key? I think for us, there are three reasons. It's developed states that have caused this problem, and in our view, there's an obligation, a duty, howsoever put, to actually mitigate the harm that emissions caused by or produced by developed states have caused. Secondly, I think there are clear economic and security reasons why states would enter into a climate change displaced persons convention, such as the one we proposed. And finally, it is a discrete problem which can be addressed in a clear and straightforward way, in ways that perhaps issues associated with poverty and environmental displacement, for example, cannot be.
I would also add that, you know, as I mentioned, the placeholder provision in the Cancun adaptation framework, which really is a preliminary acknowledgement that states have some sort of responsibility towards addressing migration and movement as an adaptation matter. And I think that maybe that's as good as it gets. That provides that acknowledgement, and then it's actually up to a range of national, regional, and then perhaps international strategies to go about implementing that in various forms. In terms of internal displacement, I just don't think you need a new treaty. First of all, you've got the guiding principles on internal displacement, which apply in disaster as well as non-disaster, sudden as well as slower onset situations, and they can apply to environmental disasters as well. And those guiding principles, although they are a soft law, non-binding framework, they are based on states' international obligations under human rights law, humanitarian law, and refugee law. And really what they do is just draw the relevant provisions together in a set of principles that are easy to see and follow. And then in terms of international displacement, something we haven't really talked about much is the role of international human rights law in terms of the non-refoulement application there. That is, that you cannot send people back to a place where they would be subjected to arbitrary deprivation of life or cruel, inhuman or degrading treatment. And while there is some way to go yet in terms of the jurisprudential development of those concepts, particularly in the present context, it's not impossible, certainly as impacts worsen, for some of these situations to be seen as subjecting people to inhuman treatment if they're sent back to a place where there's no fresh water, no agricultural land, and whatever else it might be. Now the problem there is that those sorts of protection frameworks require you to really be facing imminent harm, and preferably we'd like people to be able to find solutions well before it gets to be that dire. But there are nonetheless these existing international frameworks that I think are relevant, and that really it's about implementation of what we've got, not necessarily reinventing the wheel.
Robin Bonin from the University of Alaska. And so first, to answer Jane's question about climate change and why climate change might be the driver, it's because climate change has the potential for permanent displacement, which the migration patterns that currently exist do not have. The other difference is the collective nature of the way that climate change will displace people, and there are no frameworks, human rights frameworks, currently in place that deal with collective self-determination and having communities make the decision about where, when, and how they relocate. And so in regard to David's proposed convention, it's critical that we distinguish between temporary and permanent migration or relocation, because the policy implications are enormously different. And then as a final comment, as I've been sitting here for the last day and a half, I've been thinking about where we are in Manhattan and what we've heard about the potential for sea level rise to be 1 meter by the end of this century. And I don't know what the elevation here is in Manhattan, but if we're concerned about the Marshall Islands submerging, we should also be concerned about Manhattan. And if we're not concerned about Manhattan because we think that there's technology to protect Manhattan, then there should be technology to protect the Marshall Islands as well.
I'll just add that it's lower Manhattan that's in greater trouble. So Wall Street has to watch out. Minister Silk, did you?
Thank you. I've been fascinated with the presentation by the panelists there. And I would agree with David that we do really need a climate displacement treaty to be set aside from the other treaties, because if nothing else, it should focus attention on the issue, which is why we're here. There is no denying that there will be refugees or people who claim to be displaced because of climate change. But overall, the issue is really the disappearance of small island countries, and perhaps Manhattan too. But so I really think that if we want to address this issue, because everybody agrees that by the end of the century, the sea level will rise at least 1 meter, then we should start working towards a treaty. It takes a long while to negotiate these treaties, but we should focus our attention to start the negotiation process now. And what better way to do that than to bring attention to the United Nations, specifically to the Security Council, to address this issue. And I am happy to know that next July, this coming July, there will be a debate at the Security Council on the issue of security, which is really what's taking place as a result of climate change. Is security for small island states as well as the rest of the world, because migration will happen. And I really think that the time to debate whether there's a climate change and whether there's an actual threat of a sea level rise is over. I think the time now is to sit down and start negotiating an agreement that will come into place before we know the tipping point. Thank you.
I think in response to your comment, to the Ambassador's comment, that having a very likely standard, a 90% standard, may in fact make it easier for states to sign up to such a treaty, notwithstanding the other difficulties that attend the treaty. Thank you.
Thank you. I'm Carolina Claro from the University of São Paulo. Well, first of all, I'd like to congratulate the three presenters and to say that I'm very honored to listen to some of the main legal scholars on the subject that is so dear to me. And secondly, I wish to point out that there are some international law principles other than the ones raised here that could be applicable to international legal protection to environment-induced migration in the absence of a specific treaty and even in a future protection, such as the reciprocity principle and the solidarity principle. Some international law principles that could also be applicable at the international level to environment-induced immigrants, derived both from human rights and migration law, have already been considered peremptory norms of international law, but many states still deny application to them based on sovereignty and national interest. Furthermore, global migration governance is still an open question that should be dealt with at all levels as an urgent matter. As for a specific legal protection to environment-induced immigrants, there is no denial that a number of difficulties that arise with this effort and that the 1951 Refugee Convention is not to protect this group of people for a number of reasons deriving from the treaty itself to the practical capacity of refugee institutions to deal with environment-induced displaced people. As a specific treaty is indeed very difficult to implement, especially at the state level, but as international legal scholars, professors, lawyers, and politicians, we have at least a moral obligation to give environmentally displaced people some hope on their current and future situation. And this hope cannot be turned into effective measures if a legal apparatus is not found for them on existing legal norms and principles and on political and academic efforts to a specific provision that is so important to human rights protection worldwide. Thank you.
Thank you. Any comments on that? Mr. Cass, whose office is in Lower Manhattan.
I was going to say, Stephen Cass from Lower Manhattan. I wanted to ask Jane whether how you would feel about a hybrid which would put together some of the suggestions made by the panel, which would include an aggressive internal adaptation program of the sort you all have endorsed, and Michel's new convention to deal with environmentally displaced persons in a cross-border context only. And whether, if you would agree with that, whether Michel would agree with Jane if she would accept that.
As I said, I think we need to be looking at multiple strategies. And even though my intervention today was very much on this is why we don't need a treaty, I think that should be, the caveat should be, this is why we shouldn't only be focusing on that as the main way forward. I mean, I've outlined the difficulties I have with conceptualising a treaty in these circumstances. But that said, I think that it would not be unhelpful to perhaps draw together at least a set of guiding principles for cross-border displacement for the present context. And there are, I mean, you know, to some extent you can adapt the guiding principles on internal displacement, but perhaps it's also about getting states to be more flexible, if you like, in the way in which they interpret some of the human rights obligations they already have. And I should say too, there are some situations where people will fit the Refugee Convention definition, and Michelle highlighted some of those earlier today in her presentation. I mean, certainly I think an internal adaptation program is essential. I think we need further funding for adaptation. But one thing I would say too is that having interviewed some government officials in Tuvalu and Kiribati, a number of them said, I wish everyone would stop talking about getting some multilateral framework on this, because if you'd all keep quiet, we could just negotiate this at a bilateral level with Australia and New Zealand and it would happen. Now, I don't know to what extent that's true, but there you are talking about around 110,000 people in total. That's less than Australia's annual immigration intake. So in terms of numbers, it's not big, but certainly in terms of those issues that Robin raised around how do you maintain a sense of identity, a sense of culture, self-determination, whether it's big S or small s, sense of community, and all of those things are very, very difficult issues that, you know, none of the proposals we have, I think, will resolve. So I've slightly sidestepped the question there, but yes, I mean, and I think, you know, fundamentally, I just don't think we're going to get political agreement on a new treaty, which I suppose is the you know, no matter what theoretically I think might be fantastic, I just don't think that's going to happen.
I think in general, international law is always in progress, and we should always make progress and not have a pessimistic view as you have. I participated to a lot of diplomatic negotiation on topics where at the beginning every people said it's impossible. The states won't agree. And I can give two examples in Europe, but on general topics where you can think we are crazy to have international convention on such topics. I participated to a convention in the Council of Europe on landscape protection. Well, people said, you are crazy. What is the relation between landscape and law? It's impossible. You won't succeed. Well, the convention was negotiated, was approved, is ratified, and is enforced. Second example, in another topic in environmental law too, on integrated coastal zone management in a regional sea. Well, people said, you are crazy. It's impossible to have international convention on such complex issue as coastal zone management, which is land, sea, urban development, tourism, everything in that. Well, there was negotiation, the convention was signed, and it's in force. So I think we must have the perspective of the future and the evolution of international law, and we have the guidelines for internal displacement. They are guidelines, not binding. They are very nice, everything is in it. But why not transform that, a new step, these guidelines, in a convention and apply to cross-border displacement, but in a binding instrument? Why a binding instrument? Because it's a state obligation. And then you have, through human rights law, the individual actions to petition, to give complaints in compliance committee. It's not only a question between states, it's a question between citizens and the states and international law. And it's only human rights law which gives the right to people, to individuals, to go to some compliance committee or any organization to push the implementation of international treaty. That's the progress of human rights international law, and environmental law must use the progress of human rights international law.
Jane?
Just to respond quickly on that, one reason why guiding principles can be helpful is that they can pave the way for precisely the international, the hardening of international law obligations that you're suggesting. So, for example, the guiding principles on internal displacement were not a state-based initiative. In fact, they were quite strongly resisted by governments for a number of years. However, the African Union has now just adopted the first convention on internal displacement because they were seen as actually proving to be quite helpful in structuring state responses. So I think, not necessarily going straight in for a treaty doesn't mean that you don't get one further down the track. But as I say, I have kind of conceptual difficulties with a treaty as well, not least how you define the people to whom it will apply. And of course there are very different kinds of treaty proposals that are on the table. But certainly if you look at the way the Refugee Convention is implemented by states, that definition becomes very, very carefully circumscribed. And in fact, the way we construct our governance mechanisms can in turn shape the way in which people move. So if a treaty is something that responds in some kind of remedial way, as the Refugee Convention does, then there is a risk that people will make dangerous journeys to try and seek that protection, rather than something which I'd prefer to see, which is more proactive, where we look at how can we actually facilitate movement in advance of those very dangerous circumstances being reached.
Great. Okay. Yes, sir.
Justin Rose from the University of the South Pacific. We heard in all three of the presentations many of the reasons for resistance from why recipient countries might be resistant to the negotiation and signing of a treaty for climate change displaced people. What was noticeably absent, I think, from the presentations, particularly the ones proposing the treaty, were the possibility of, or indeed any statement regarding the wishes of countries that might be sources of these people to drive this through international forums. We heard Ilona Miller talking in an earlier session about the loss and damage mechanism, which small island states have been united on, which have been advocating very strongly for within UNFCCC processes for some time, which has not yet been finalised, which has not yet received any agreement. What we didn't hear was, and I think Minister Silk's intervention just now was the only comment that I've come across from potential recipient countries actually wanting such a treaty. In fact, USP's done some empirical research in the last few months, which has gone out into 4 of the key potentially recipient countries and asked exactly this question. They haven't, our respondents haven't shown any interest in this. In fact, what they said was exactly what Jane said, which was if there's going to be such a treaty, we'd like it to be negotiated on a bilateral basis or perhaps a regional basis with countries which we've already got relationships with. And so I guess my question is to the two proponents of the treaty, is there any call for such a treaty from the countries which might be sources of the CCDPs? And if not, if the recipient countries are going to resist it, and I can think of many reasons why source countries would resist it, we've heard them stated very clearly in this conference regarding countries not wishing to begin talking on an international level about displaced people because they want to do everything they possibly can to maintain themselves on their homelands. And there's many other aspects of displacement, even within the Pacific Islands, which indicate the complexity and the diversity of the reasons why people might choose to migrate. So if there's no push and there's no pull, what possibility is there for an agreement this kind of treaty?
If there's no push, if there's no desire from, for example, small island states, then there would appear to be no point for a treaty at all. And in fact, the basis of our proposed convention is a regionally based, localised one. So, for example, with a global organisational framework, together with funding from the world states, it has as its core regional-based initiatives, regional agreements between affected states. But I take your point. If no call from regions, if no call from those affected by the effects of climate change want a displacement treaty, then again, no point. Certainly the evidence that I've seen in terms of a range of small island states, there seems to be a great deal of appetite for examining the issue and for looking at what a treaty might contain and the possible advantages of a treaty. And it's on that basis that our project has proceeded.
So let me make this suggestion. We have a break to come up, but we have the panel. It's not a panel. It's some time afterwards for the way forward. And since there are a lot of people here from source countries and a lot of people here from recipient countries, perhaps one of the things we can talk about after the break is this kind of question. What is the receptivity or lack of receptivity to this kind of a treaty? Let me just say a word about the dinner that's coming up afterwards. In order to, everybody who is registered for the conference is very welcome to come to the dinner. You don't have to register separately for the dinner. But we do ask that you have registered for the conference, which means you have a name tag. It's in Low Library. We'll give instructions on how to get there. It's a very nice dinner. It's not being served in a box, and you'll hear the president of the Marshall Islands and others give talks. So right now we have a 15-minute break out in the hall, and we will resume at 4:15.